good to be with everyone else on today's webinar. Thanks for the feedback you provided after my last session, March 22nd. We did get a better response rate there, so thank you for that feedback and your ideas about future topics. I encourage you to do that. I think got up to about 20%, so double our usual 10%. Let's see if we can't push that up a little bit more today. So again, I welcome your feedback at the end. We do take it to heart. It's very valuable. So we got a great group today. Once again, we're going to cover some recent developments in the area of the Freedom of Information law here in New York. We're going to talk about a New York labor law statute, relatively new one that was deemed unconstitutional in part, and I think that'll be interesting to everyone on the webinar here. And then we're also going to have another presentation by the authors who literally wrote the book on New York labor and employment law dealing with discipline. And then I'll wrap up just at the end with an update on where things sit COVID-wise and address a few FAQs that I've been dealing with recently. So without further ado, I'd like to turn it over to my colleague, Jacqueline Giordano. Jacqueline is an associate who works in our Garden City office, so one of my colleagues who I have the pleasure of working with here at Bond. And Jacqueline wanted to present today on a recent development under the FOIL law. And I think for all employers, not just public sector, but this issue can come up from time to time, whether seeking records or potentially having records in your possession that are subject to FOIL. So Jacqueline, thank you for joining us. Great to have you.
Thanks for having me. So good afternoon, everyone. I'm here today to talk to you, as Andy mentioned, about New York's Freedom of Information law. And for our public sector clients, I hope this is just a nice refresher of things that you already know. But for those in private industry, as Andy mentioned, I think it's useful to know about New York's FOIL law because if you do any business with public entities, your bids, RFPs, and other exchanges with those entities may be subject to FOIL. So it's good to have this background in mind. So starting off, New York's FOIL law can be found in Public Officers Law, sections 84 through 90. And the FOIL law requires public agencies to allow its records for public inspection and copying unless they are exempt from disclosure. So agency under the FOIL law means any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or any of its municipalities, except the judiciary or the state legislature. So in essence, this means your local library, this means villages, towns, cities, police departments, and of course, the state of New York. And a record includes reports, statements, memoranda, opinions, books, manuals, pamphlets, drawings, photos, letters, and even emails. And overall, it's good to keep in mind that the law requires a presumption of access. So when the law was first adopted in the late 1970s, it was on the premise that citizens had a right to know the process of governmental decision-making and to review documents leading to those governmental determinations. However, there are some exemptions under FOIL law, some records that are not subject to disclosure. In the next slide, we have a beginning list of those exemptions. They're found in Public Officers Law, section 87. And one of those first exemptions is if a record is exempt under state or federal law. So one of those examples would be income tax information that's exempt under the tax law, or juvenile or youthful offender records that are exempt under other criminal statutes. Kathy, I think if you could just advance to the next slide. Again, so that's that first exemption. The second exemption listed under the law is records that, if disclosed, would constitute an unwarranted invasion of personal privacy. So sometimes portions of records may be redacted because it would constitute an invasion of privacy if it has an employee's date of birth or some other really confidential private information. Another exemption specifically stated under the law are any records that, if disclosed, would impair present or imminent contract awards or affect ongoing collective bargaining negotiations with public employers and their bargaining units. A fourth exemption, which recently I've had some interaction with, is the trade secret exemption. So under this exemption, it's trade secrets or other information that would cause substantial injury to the competitive position of the subject enterprise. So for those private sector clients out there, this is something to keep in mind. If you submit bids to public entities, part of your bid may need to be redacted under FOIL because it's a trade secret. However, there's a very specific definition of trade secrets that the state has published in their Committee on Open Government Opinions. So a trade secret may consist of any formula, pattern, device, or compilation of information which is used in one's business and which gives them an opportunity to obtain an advantage over competitors. So this could be a formula, but it could also be a list of customers. And notably, a trade secret, as you would predict, must be a secret and must be not be of public knowledge or of a general knowledge in the trade or business. But like all these exemptions, they are to be interpreted narrowly and in favor of access to the information or documents. And lastly, before the next slide, another exemption listed under the law is if a record is disclosed, it would endanger the life or safety of any person. Now, as we continue down our list of exemptions, these two that I listed on here are ones that I come into contact with more generally as well, and they are interagency or intra-agency materials, which are not statistical or factual tabulations or data, instructions to staff that affect the public. So those instructions to staff, those factual tabulations, those are subject to disclosure, but final agency policy or determinations and external audits. And lastly, and one of the more hot button topics in terms of FOIL requests are requests for law enforcement records. So certain law enforcement records are exempt from disclosure under FOIL, and it's if disclosed, those records would deprive a person of a right to a fair trial or impartial adjudication, identify a confidential source, reveal criminal investigative techniques or procedures, or interfere with law enforcement investigations or judicial proceedings. So that last exemption under law enforcement records, those records which would interfere with ongoing law enforcement investigations. This very recently had a change. On the next slide, I go into more detail that as of December 29th, 2021, New York had enacted a statute, a procedural hurdle requiring agencies that cite to this law enforcement ongoing investigation exemption to follow a specific judicial review process. So if someone requested the law enforcement documents, they would have to, the agency citing this exemption, so the police department or the district attorney's office would have to notify the person requesting the documents that they're going to be using this exemption. They will not be providing the records. And then it would have to go before a judge to decide whether, in fact, those documents should be disclosed or if they're subject to this exemption. However, 3 months after this was enacted, on March 18th, 2022, it was rescinded. So now if a law enforcement agency is citing this exemption, they typically don't have to do anything if they're the investigating agency. However, if, say, for instance, a town police department has records regarding an arrest, but however, the district attorney's office is continuing the investigation on that same arrest, and the local town police department receives a FOIA request and they use this exemption, they would have to reach out to the district attorney's office to get confirmation that them disclosing these records would impede an ongoing investigation. So that's the only hurdle that now exists to use this exemption, and it's effective retroactive to the initial date of that judicial procedural hurdle of December 29th, 2021. So there's no gap in the law, basically. And lastly, I just included a slide that has some things that you should know about FOIL, generally speaking. Most agencies have a records access officer or a FOIL officer, and that's the person to whom FOIL requests should be directed. It's a great way for the municipal agency to just kind of keep track and organized in terms of how many requests they receive and to respond to them in a timely manner. Lots of times, if it's a small village, it might be the village clerk. If it's a school district, they might just have someone call the records access officer who's also a district clerk. It really depends on the agency. And lots of this information in terms of who a FOIL request should go to can be found on websites. And then in terms of responding to FOIL requests, the law requires that the agency respond within 5 days business days, I'm sorry, of receiving the request. And they either respond by saying, we'll make the records available and providing the records, denying the requests and providing the reasons for that such denial, or writing that they've received the request. However, they're going to need a specific amount of time to respond. Sometimes it could be a quite lengthy period of time. It just depends on the volume of records you're requesting and really the accessibility of those records, and if any of them may need to be redacted. And lastly, I think I mentioned earlier, there's the New York State has a committee on open government, and they publish opinion letters that are available online that provide an analysis of the application of these exemptions and what is required to be disclosed under the law. So that's a helpful tool if you're ever curious as to what may or may not need to be disclosed. And that's all I have for you today.
Yeah, thank you. That's a very helpful overview. We have many municipal entities subject to FOIL who attend this webinar every week. So I know they appreciate having the overview and certainly the insight on the recent developments dealing with law enforcement. And yeah, you're wise to point out the Committee on Open Government resource there. I have to say, back in the days when I was an associate doing the research, it was a great resource, but also surprising at times to see the interpretations that the committee at least was taking from its purview and factoring those things in too. So thanks. I hope you'll come back and join us another time.
I hope to. Thank you.
All right, great. All right, so next up, I have one of the authors from our book here at Bond, right? New York Employment Law, Jeff Kale, joining us. And Jeff is going to talk to us today a little bit about discipline. And I have my book open, Jeff, here to a chapter that, in addition to all the editing that you and Lou worked on, dealing with discipline. And today you're going to talk a little bit about the 7 steps of just cause.
Well, we'll certainly get there.
Great.
This is Lou's favorite chapter, mostly because he wrote it, but I like it too because I edited it. And to start off, I'm one of those people who spent most of his life wondering what I'm going to do when I grow up. And I'm still wondering about that. It was certainly the case when I was in law school. And by the time I was through with my second year, my father thought that this wondering was a basic defect in my personality. So he said that I should meet with an older friend of his who was a crusty old lawyer and get some direction. And I met with this gentleman in a deep, growly voice. He said, "Kid, I only have one question for you. Are you interested in takeoffs or are you interested in crash landings?" I didn't know what that meant. So he explained that lawyers who do takeoffs are the transactional lawyers who assume that everything will go wonderfully. And lawyers who are interested in crash landings are the ones who pick up the pieces when those deals go sour. I thought those were both pretty interesting. I tended to prefer crash landings. And then when I got into practice, I discovered employment law. And we have the luxury of doing both. We do the takeoffs and the crash landings. And every time we encounter a crash landing, we learn a little bit more about how to take off properly. Well, when you're dealing with human resources and employment, probably the biggest crash landing you run into on a regular basis is the employee who just has to be disciplined or terminated. And that in turn can lead to another terrific crash landing when you botch the process and end up in court. So it's good to review some of these principles. And I think the first question that many employers will ask is whether or not they have to have a discipline policy. And the short answer to that is in New York State, no, you don't have to have one. If you have a union contract, it's virtually guaranteed that the union will have wanted to negotiate one with you and probably has. If you are a public sector employer, there are all sorts of statutory requirements for discipline policies. But if you're a non-unionized private sector employer, there is absolutely no requirement that you have any kind of formal discipline policy. And you can, at least in theory, follow the concept of employment at will, which we discussed in chapter 2 of the book at some length, which is essentially that an employee can be disciplined or terminated for any reason or no reason, so long as the reason is not unlawful, in violation of a protected right, or in violation of a contractual right. I don't have to tell you. It's not that simple. And there are a number of reasons why employers should give serious thought to having formal discipline policies. Most of them speak to the crash landings, but there are positive reasons as well. One that is a positive reason and speaks to crash landings is if you have a formal policy that you can follow, you will get fairness and predictability in terms of your results as from one employee to the next. And that perception is very important to the morale of your workplace. Also, unless you want to fire everybody when there's cause for discipline, you can use a discipline policy to improve employee performance. And most employers will want to do that. A third reason for having a policy is if you are a large employer, the responsibility for discipline and employee development is going to be delegated to managerial employees. And you want them to have some guidance, and you want all managerial employees to behave in reasonably consistent manners. And then we get to the crash landings. You may have had an employee at will whom you could have disciplined or took discharge for any reason or no reason, unless blah, blah, blah. But what you are going to find out very quickly, and many of you have found out, first, if it's a union environment, there's going to be a grievance that the policy wasn't followed and there wasn't just cause for the discharge or discipline. And if you're not in the union environment, there's a very good chance that you'll be looking at litigation of some sort of human rights claim, either that the real reason why you acted was discriminatory or in violation of some other protected right, or even a general argument, I was assured that there would have to be just cause and this was arbitrary and capricious. So if you have a consistently administered and appropriately documented discipline process, you're going to be in a position to respond to that. It also goes beyond the four corners of your workplace. If the guy who came in to service the water cooler got into an argument with your sales manager and it reached the point where your sales manager decked him, you can probably expect to be sued by the water cooler guy. Again, if you have had in place a meaningful and articulated discipline policy, you will be much less likely to be accused of failing to supervise your employees, and you'll have a defense. Now, another thing that it does do, a discipline policy which has steps short of termination as the first option, does improve employee performance. And we had a question pop up in the question box. You know, there are some things for which we don't want to follow progressive discipline. If we have an employee who consistently refuses to enter his or her time until days, weeks, or months later, and if keeping accurate time records is of the essence to the operation of that employer, do you really want to have to go through the whole process of a verbal warning and then counseling and then a last chance letter and then finally some sort of termination? Well, there are a lot of good reasons for having progressive discipline, but any progressive discipline policy that you have should include a clause that says progressive discipline will not be used in all cases. There are cases of sufficient seriousness that more immediate discipline than the preliminary steps up to and including immediate termination will be applied. You don't want to lock yourself in on that. So if you're going to talk about what you should have in a discipline policy, you should have a range of possible sanctions for misconduct. You should have some examples, not a laundry list, examples of the kinds of things that will lead to discipline. And that can be attendance, performance, interpersonal relations, relations with clients, accuracy of work, and that sort of stuff. What you don't want to do, and there's sometimes a temptation when we're asked to develop these policies to do it, well, if you're late to work once, then the penalty will be X. If you're late to work more than 5 times, the penalty will be Y. Our suggestion is that you don't lock yourselves into that. I do want to give one particular carve out. We spent a lot of time in the book in chapter 11 on discrimination, and in particular as it affects workplace sexual harassment. Discipline for sexual harassment is a separately evolved body of law, and you really have to think about your harassment policies and the state and federally imposed standards before you get into discipline there. What is going to happen very often, and this is Lou's favorite topic, is, okay, we have disciplined someone. Let's assume we've discharged an employee for what we consider to be serious misconduct, and we are now in litigation either on a claim that there was discrimination or a union grievance that we failed to comply with just cause as set out in the union contract. And the concept of just cause creeps in all the time, whether or not it's explicitly written down. Why? Because if you're being accused of having an improper motive, you're kind of going to be called upon to say, well, no, that's not why we terminated this person. We did not terminate him for being left-handed and from Slovovia. We terminated him because he was absent 30 out of 60 days in a 3-month period. So you are going to find yourself backing into just cause. And it is helpful to know, and we address this in chapter 10, what do tribunals look at when they're trying to determine whether an employee had just cause for an adverse disciplinary action? And there is a 7-prong test, which has been developed over time. It was first developed by an arbitrator named Carol Doherty. That's Carol with 2 R's and 2 L's. He's a gentleman. And it's been carried forward many times. So if you have to establish that you had just cause, or let's call it a good reason for disciplining someone as you did, question number 1, did this employee know in advance from you that this kind of conduct could lead to discipline? In other words, did it come out of the clear blue, or did any reasonable employee working for you have reason to know that if you do this stuff, bad things are going to happen to you? That's a good thing to have in the policy. Was the conduct for which the action was taken reasonably related to the orderly, efficient, and safe operations of the employer? Now, we all encounter that in different places. New York State labor law protects employees against adverse action for non-work activities which are otherwise lawful. And I think we are all pretty much aware of that. But it's an important question. Was the discipline for something absolutely trivial, or was it the discipline for something which, if left unaddressed, was going to impact the employer's operations? The third factor, and this is a big one, before you impose discipline, did you make an effort to find out whether, in fact, the employee engaged in the misconduct? I'll give you a raw example of that. A line supervisor reports to you that somebody on the production line got into a fist fight with another employee. And you say to him, okay, well, if that's the case, fire him out of here right now. What if you didn't do it? What if your supervisor misunderstood what was happening, wasn't there or took it on hearsay, or is acting out of personal animus? You certainly don't want to find out in a litigation or a labor arbitration that this fellow you fired for getting into a fight actually did not get into a fight. Find it out before you take the action. And as a corollary to that, was what you did to find out fair and objective? You really don't want to be saying, well, I took the line supervisor's word for it. Ask somebody else. Check it out. A third corollary of that rule is, was there substantial evidence that the employee did it? You don't have to prove it to a certainty in a court of law. You don't have to prove it beyond a reasonable doubt. You don't even have to prove it by what's called the preponderance of the evidence. Substantial evidence under New York law means, was there evidence sufficient to lead a reasonable person to the conclusion that it's more likely than not that this happened? But you do have to make that good faith effort. The sixth of the Carol Doherty rules was, in imposing this discipline, was the employee consistent with its applications of the same rules, orders, and policies as the employer was with other employees? If you find yourself with grossly different results for similarly situated employees, a reviewing tribunal is going to take a real hard look at whether your reason was the real reason or whether the reason proffered by the employee, which goes to reinstatement and damages, is the one that ought to be believed. The final one of the Doherty rules is, was the discipline reasonably related to the seriousness of what the employee did? And as I mentioned earlier, some of that goes toward progressive discipline, but you don't want a real disjunction here. You had an employee who has served you faithfully for 35 years and was absent 3 days in a row without producing a doctor's note, and you fired him. That's going to be fairly tough to defend because it really is an extreme action for someone who otherwise had a blameless record. Now, I've given you 7 principles there. You do not have to answer every one of those by proving that you were as pure as the driven snow, but you have to be able to address most of them. And as Lou would like to tell you, there are 2 De Lorenzo corollaries to the Doherty rules. Those are, before imposing the discipline, was the employee entitled to some sort of reasonable accommodation for a religious belief, for a disability, for a medical condition, for a family situation, or something else? And believe me, this book is full of examples of reasonable accommodation that would constitute an excuse. Don't jump too quick on it. Also, and this is a good point, has the employee recently engaged in protected activity? And mostly means union-related activity, which would cause a trier of fact reviewing the situation to say, I know that you said you terminated this employee for his absence record, but isn't it interesting that you first started scrutinizing his absence record when he began handing out union cards during his lunch break? And that's going to be a real problem. So Lou's point is, before taking the action which you otherwise think you're entitled to take, ask yourself those 2 sets of questions, because a good takeoff on those is going to avoid a crash landing later on. Now, Andy, how are we doing on time here?
Jeff, we're doing great. That was a very helpful overview. And in the interim here, Lou's also joined us. And with that background, walking through the 7 steps, which again, you can get more depth and detail on in the treatise that Lou and Jeff have authored and edited. But Lou, one question that might be in the minds of the attendees here, right? It might seem daunting, right, to think about having to process and work through these 7 steps and the 2 corollaries. What's your advice for them as they think about handling discipline and documentation on a daily basis, and recognizing, right, their plate may be very full, and HR may be one among many duties that they have.
So just a couple of comments, and I'm sorry I couldn't join in with Jeff's presentation, but I'm sure it was terrific. One thing is, you've always got to be honest, Andrew. Andy, we always got to be honest, right? Evaluations, discipline. We can't be in a situation where we're giving somebody terrific evaluations for all these years and then take a right turn and say, they really haven't been as good as I've said, but it's hard for me to tell people that they're not doing a good job. This person flies off the handle. They have borderline personality. We're always on eggshells around them. You've got to give the evaluation straight from the shoulder, good, bad, or indifferent. The other thing is you got to pay attention to time. There's a time to hire somebody, and there may be a time to fire somebody. And if the time comes, you should exercise. If the discipline's warranted, if I had a nickel for the situation that Jeff just described, where somebody calls me and says, hey, this person did X, Y, and Z, and I want to terminate. And we check under the corollary to see if they've been engaged in any protected activity recently. And they say, well, they did go out on FMLA leave, or they did try to start a union, or they did do this, or they did complain about wage and hour issues or our overtime policy. And I say, gee, I don't know if we could fire them. The temporal proximity of the protected activity in this decision is so close, somebody's going to infer that that was the cause of the discipline or the discharge. And then they'll say to me, no, it has nothing to do with that. In fact, we caught this guy drunk on the job a year ago, or we caught this guy stealing 6 months ago, and we gave him a pass. We're not out to get him, but we gave him a pass. I say to them, those are even worse facts than the ones you just gave him. Your time to fire that person was when you caught him stealing. Now, because you forewent the stealing, how serious does it look that he's got an absenteeism problem, or he talked back to a supervisor, or he refused to carry out an order? That to me looks less serious than stealing, and we didn't fire him for the stealing. Now we're firing him for a lesser offense, and it's after the person is engaged in the protected activity. So you got to be honest, Andy, on performance issues, whether it's evaluations or raises or bonuses or discipline. And the other thing is that when the time comes for the discipline, like they say, put a fork in him, he's done.
Yeah.
You got to do it. You got to do it. You can't pass on those opportunities. When you pass on them, they're not only used against you with respect to that individual, but somebody else who does the same thing, who has a protected characteristic, who you now decide to fire. You passed on somebody else. You got to be consistent. I'll stop.
And that means that you have to step back from the situation and take a look at the whole thing, as Lou just said, to make sure that you are not aiming your vessel at an immediate crash landing.
And the 7 steps I carry in my wallet, I have them on my nightstand because people call 24 hours a day, 7 days a week. I'm ready to fire this person. What do you think? And I always worry about leaving a consideration out. The 7 steps and the corollaries are not things that you have to be able to answer positively for each one before you can fire somebody, but it gives you a sense of what kind of risks are we taking? Where do we have weaknesses in our termination decision? Maybe we can take a few steps to make them stronger before we pull the trigger. Maybe there's a long-term suspension in this person's future, and they're not going to change anyway, and that's going to make it easy. Maybe it's a performance improvement plan, but at least you can take your blood pressure and temperature of the risk that you're going to assume, because in my mind, there's no higher risk than the termination decision in terms of potential liability, other than a class action. But as far as the case goes, that's the one.
You're right. Great advice, great guidance. Folks, if you don't have it, I encourage you to pick up the treatise that Lou and Jeff authored and edited. Again, Schoeneck King, we don't get any royalties from this. This is something that Lou has worked on and that Jeff assisted with as a service to the community and to you all who operate in the labor and employment realm. What's the best way, Jeff, for folks to get a copy of this book if they'd like one?
Well, the easiest way, if you're a member of the New York State Bar Association, is to buy it through NYSBA. We are told that there is a more difficult way to buy it through NYSBA if you're not a member, and I'd certainly encourage people to try it, but if worst comes to worst, it is on Amazon. It is called New York Employment Law, The Essential Guide, and if you can spell Schoeneck King or Louis P. DiLorenzo, you will find it on Amazon.
Great.
I know, Andy, a lot of people are waiting for the movie, but there's been some real hold up on the negotiations. Jeff wants Leonardo DiCaprio to play him, and he's holding out. So I wouldn't wait for the movie. Just go ahead and buy the book.
Oh, hold firm, Jeff. I agree. Get the best. And there is a link at the end of the presentation today, folks, that you can access to get to purchase the book as well. If you have trouble with it, let me know. Reach out to Lou, reach out to Jeff. We can help you. So, gentlemen, thank you very much. Appreciate it. I'm going to talk a little bit at the end just about where things stand with COVID. But before we do that, Janelle Doobie from our Syracuse office, she is an associate here in our labor department, wanted to give you a brief update on a development that probably is something that's on your radar screen in terms of the underlying issue and change in law. But I was interested and surprised to hear about this particular development and thought you might be too. So Janelle, thanks for joining us today.
Thanks for having me. So hi, everyone. Today, I'm going to be discussing a recent federal court decision that struck down a portion of the New York labor law that previously required employers to include a notice regarding employee reproductive health decisions within their employee handbooks. So just for a little bit of background, Section 203E of the New York labor law, which was enacted in the fall of 2019, prohibits employers from discriminating or retaliating against employees based on their reproductive health decisions, including using or accessing a particular drug, device, or medical service. Within Section 203E is this specific notice requirement that requires employees who have handbooks to include in those handbooks a notice of employee rights and remedies under this law. So in a case captioned Compass Care v. Cuomo, several religious organizations sought to permanently enjoin the enforcement of this specific notice provision, claiming that this requirement violates the First Amendment of the Constitution. The organizations basically claimed that the requirement compelled them to convey a message with which they disagree, specifically as it undermines their purpose as organizations who adamantly oppose abortion. So in response, the state argued that the notice provision merely just requires employers to provide factual information of the existence of employee rights under New York law. They also argued that the requirement didn't require employees to take a position on the statute or the protections it provides, nor does it even require New York employers to provide a written handbook in the first place. So the U.S. District Court for the Northern District of New York agreed with the religious organizations and found that the notice provision violates the First Amendment in that it compelled the organizations to deliver a message that was directly contrary to their beliefs as it relates to reproductive health decisions. The court essentially reasoned that the organization's handbooks contain workplace rules, the organization's values, and the religious perspective that guides these organizations' operations. So as such, the court held that requiring these organizations to include in their handbooks a statement that the law protects employees who engage in behavior that is contrary to that promoted by these organizations would compel them to promote a message about conduct that is contrary to their religious perspective. So in applying strict scrutiny to this constitutional speech issue, the court basically found that although the state of New York has a compelling state interest in protecting employee privacy that's implicated by these reproductive health decisions, the means by which they sought to achieve this compelling interest were not narrowly tailored. So basically, the state failed to demonstrate that the notice requirement was the least restrictive method of achieving the protection of employees' privacy. To support this assertion, the court highlighted evidence that the state has previously provided worker rights and remedies information in a variety of other ways that has not forced employers to produce the speech themselves. They specifically pointed to advertising the statutory provision generally, producing posters to be placed in workers' view at job sites, and in general statements of workers' rights that are provided by the New York State Department of Labor. So the court found that based on the evidence of this past practice, there were less restrictive means available that wouldn't require these organizations to include this information in their handbooks under the guise that the employers endorsed it. So it remains to be seen whether or not the state will appeal this decision. However, the ultimate effect of the decision is that covered employers in New York are no longer required to include this notice provision within their employee handbooks. So just to reiterate, it's important to note that the decision only struck down the requirement that employers provide notice in their employee handbooks and does not invalidate Section 203E's anti-discrimination and anti-retaliation protections for employees and their reproductive health decisions.
Janelle, great, Janelle. Thank you very much for that overview. So again, what I'm reading, the takeaway here is if you have the provision in your handbook, you don't have to anymore. And I think what I would recommend is if you're contemplating whether or not to remove that section at this point, well, there's no compelling requirement that you have to remove it. And I would recommend that you do speak with legal counsel in evaluating that option. And certainly Janelle can be helpful if you have any questions on that front. And to the extent you've already amended your EEO clause or other listings that contain protected classifications in your employee handbook, well, you should still include the reproductive health decision-making as a protected category there too. So Janelle, if you could keep an eye on that case for us. If there's any additional news by way of appeal or otherwise, it'd be great to have you back. Thanks.
Absolutely, thanks.
All right. Well, we have just a few minutes left here. Why don't I quickly go through what I'm seeing in terms of the COVID trends. The first slide that you'll see is the national case slide that I've continued to present every week. The stats that we're seeing here continue to be positive, seeing some variability in the 7-day average. But again, it's all within a consistently low range and variability within that low range. You see the 7-day average in the top right-hand corner as of yesterday, as compared with the 11th of March going back. So again, continued good trends on a national level. I did take a peek at some of this New York State data. You'll see on the next slide. I'm sure you've seen, I've heard in the news, if we could go back to the slide before that. Thanks, Kat. That we are seeing increased incidents here in New York. And again, the data that Johns Hopkins has assembled supports that. We're seeing an increase in the 7-day average and the overall volume of cases. And so the uptick is quite clear on the graph that you see. I guess I feel compelled to say that we're still well below where we were not that long ago. Hopefully this trend does not continue and that we see further progress here in New York. So where is this an issue in New York? And you'll see the CDC has established new criteria for what determines a high-risk area. And on the next slide, you'll see the map of New York, and the areas that are of concern are really right here home in central New York. So Onondaga County, Jefferson County, and Cayuga County, as well as some of the counties below us in the southern tier. Our area is classified as being a higher risk area than the others. So again, we're going to continue to monitor this. There's nothing immediate that needs to be done by way of state or federal requirement flowing from this designation. But again, it's an indicator and something we're keeping an eye on. And I guess it remains to be seen whether local, state, or federal officials implement any changes as to what we're experiencing and have to do on a day-to-day basis. So just a couple FAQs that I wanted to cover very quickly for you on the next slide. Again, most of these relate to COVID. Hey, the HERO Act, right, is still on hold. The designation was not extended, triggering activation of our HERO Act plans. That has not been extended further last I checked. Again, those plans, we still have to have those plans. They're just back on the shelf now, and that's where we need to keep them. The question that I've gotten frequently is, well, do we still need to have that plan reflected in our employee handbook? And there, I believe the answer is yes. We do need to have that, just like we had to have those plans in place before the emergency designation was first triggered. Again, we need to have those plans at the ready, but they're not activated right now. What about employee masking? Well, again, putting aside any particular sectors that may still have masking requirements here in New York, there isn't a general masking requirement. The trigger and flow down from the HERO Act is no longer in place. So again, it's typically left to employer discretion on how they address that. Now, the CDC guidance that's out there does have some recommendations with respect to masking, depending on the risk assessment and what the status of the particular jurisdiction has. So that's something that could inform policy and decision-making on the part of employers, but does not necessarily control that policy and require a particular outcome. COVID paid leave, I get this question again with seeing the upticks that we've had here in central New York. This question continues to come up. A couple points on this, right? That there's no sunset date on this particular legislation. Also, it's not an annual bucket of leave under, I think, the fairest interpretation of the statute that gets replenished every year or on some other basis. What the state had provided by way of guidance some time ago is that there are basically 3 bites at the apple for an employee. The first bite, if it's them testing positive or they're exposed to somebody and subject to quarantine as a result, or the second and third bites at the apple if they themselves test positive. What I would recommend at this point, if you find yourself in a situation, this issue again is still relevant. That statute is still on the books. There still is the potential for employers who are covered by the statute to have to provide that paid leave. But again, you're going to want to work with legal counsel when that issue comes up because there is some complexity, there is some uncertainty as to where things stand right now. Finally, I think every week we get a request from folks, hey, can you give us a list of all the new things that we need to include in our employee handbook? I wish it was that easy and we could simply provide that guidance. The reality is what you may need to include in your employee handbook is going to be dependent on a number of factors, not the least of which is the size of your operation, what sector your business or organization operates in, what other jurisdictions outside of New York that your business or organization may also operate in. So there's no one ready list that we could provide, but what we can do is provide assistance and review your handbook. Again, we work with employers every day conducting this very same function, and we stand ready to assist if you need legal review of your employee handbook. We can help with that. All right, everyone. Sorry for the rush there at the end. You see everyone's contact information on the screen here. Thank you to all of our presenters. If you have any questions, please feel free to reach out to them directly. And in the meantime, please be safe and be well. We'll see you next week.